Thank you so much, Liz. All right, thank you so much for coming here today. Again, my name is Alexandra Furtado, and I work about 10 minutes down the road in Dedham at the Norfolk Law Library. If you do want to visit us in person, but thank you so much for letting everyone know. You can contact us via Zoom, you can call us, you can chat with us online, you can email us. Any way that you would like to contact us, you can. So we're going to go over a ton of information today about landlord-tenant basics and law. So don't feel like you have to remember everything that we're going to talk about, because we're going to go over a lot of information, but feel free to take pictures. Again, I'm happy to share the presentation. And if I'm also going to talk a little bit about resources that you can use to try to find this information again. If you're like, oh, she said something about security deposits, you'll remember how to find that through our website here. So let's get started. All right, so whether you're a landlord or a tenant, this type of law can be really tricky to understand, especially for a non-legal professional. So that's what we're going to talk about a little bit today. So again, we'll talk a little bit about resources that you can find this information, and then we're going to review some common issues about topics like leases, utilities, getting repairs made, security deposits, and eviction. So if you have any questions, feel free, you can either wait until the end, where I'm happy to answer any questions you might have, or if you have a short question in the middle of the presentation, feel free to raise your hand and we can answer the question then. But before I get into all of the information, one of the main resources that I want to tell you about is something that we actually create at the trial court law libraries. So these are what we call our law about pages, and they're guides that we, the law librarians, create. There's actually 15 locations, so you don't just have to go to Dedham. We're all over the state and or the Commonwealth. And basically, it's not just landlord-tenant, it's any sort of legal topic that you can possibly think of. We most likely have a law about page regarding this, but obviously today we're going to focus on the landlord-tenant ones. So if you go to our website, which is mass.gov/lawlib, right there at the top, they're right there on our homepage, and they're organized either by general topic, or as you can see, there's a link to an A to Z list if you want to get to a specific page right away. But if you clicked on the guides, you would see one on housing. And the housing is going to be broken up into owning or renting. So obviously we're going to focus on renting today. And these are all of the pages that are just under renting in Massachusetts. So we have anything that's even remotely related to landlord-tenant law. We have a specific page on eviction. We have a specific page on security deposits, even snow and ice removal, because we get a lot of questions about that, especially during the winter. But let's focus on the landlord-tenant page. So most of the law about pages are going to have a structure similar to this. So whether you want something about landlord-tenant, or later on you have a question about family law, all the pages are generally going to look or be structured in this way. So first, we're going to have something that we call a best bet. So that best bet, I actually have a paper copy here, is called Legal Tactics. And I use this primarily to create this presentation. So oftentimes, because this is written specifically for tenants and not landlords, a lot of it is going to, when it says you, they're going to be talking about the tenant, but it's a valuable resource for either side, and especially because this is completely online, available online for free. That's what that link is. So you don't have to purchase the book or anything. You can go right to Legal Tactics and get a lot of information about the topics. And we'll take a look at this in a second here, but after the presentation, if anybody wants to take a look at this, you're more than welcome to. On the flip side, I believe this is listed under print resources. We also have the Landlord Survival Guide. So really on either side, we have information. So again, I'll put those over there if you want to take a look at those later. But these best bets are going to be links that answer a ton of different questions about whatever topic. And again, it's going to be free, open to the public. You don't have to log in. You don't have to pay for anything on these pages at all. On this one, just because, and we'll talk about the broker's fee in a second, because there is a new law, we also curate these ourselves, and we update them as frequently as possible. I currently have Google alerts on all of my pages. Actually, spoiler alert, landlord-tenant law is my page. So if you ever find anything that you want to add on here, this is my responsibility. So we want to make sure that the current laws are available right away on here too. So we do have that alert right there on the top. After the best bet, you're going to have links to Massachusetts law. Again, free, open to the public. You can read the text of the law right after you click on these links. These are generally going to link over to the legislature's website where all of the Massachusetts general laws are available to the public. Here, as you can imagine, there are a lot of landlord-tenant laws. So we just have it on the chapter level, that first law. But if there are other related laws or special laws that we want to draw attention to, we're going to pull those out. So I always like to point out Chapter 93, Section 114, which I like to call the ghost law. So if you are worried, if you believe in ghosts and you are worried that this new dwelling that you're moving into might have a ghost, they don't have to tell you if anybody else has reported ghosts, but if you ask, the broker has to tell you, which I think is really funny that that is specifically a law in Massachusetts. So important if you believe in ghosts. And then we're going to have Massachusetts regulations. So these are still law. They're just administrative law that are created by departments and agencies in Mass. So the important one that I'm going to reference a couple times during this presentation is the State Sanitary Code, which is enforced by the Department of Public Health. This is going to be the regulation that governs that you need to have hot water in your apartment, that you don't have to have mold or critters running around, that there needs to be like a minimum temperature that your apartment can sustain, that kind of thing. So that's all going to be found in the State Sanitary Code. And then we're even going to have cases. So here we just have the link, but if you followed the link, you'd be able to read full text cases that talk a little bit more or go into more specific topics within landlord-tenant law. So you can view those cases as well. Here we have forms. So if you're looking for housing court forms, you can find those links. And then we also have the special section here on reporting a code violation, which we'll talk a little bit about later on in the presentation, how to report a code violation in your town or city. And then finally, we have, or second to finally, we have web sources. So again, free, open to the public. These are going to be materials that are either on mass.gov or another website. Sometimes we'll even have lawyers' blogs or just other links that are important here that we want to share. And again, we ourselves, the law librarians at the trial court law libraries, are reviewing all of these constantly to make sure that they're still good law, that it's good information, and that it's up to date. So, and if there's ever like a change in here, then we update it as soon as we possibly can. And then finally, the one thing that you might not be able to immediately access on these pages is the print sources, because as the name suggests, these are materials that are in the library. However, if you do have a library card with us, you can access the ebook versions of these. So, or like you'll see here, actually I might have cut it off beforehand, but the Landlord Survival Guide is here, so you know that this is a title that we have, and you can visit your local law library and view this in person or check it out if you have a library card with us. And then Legal Tactics, as I mentioned, is completely available for free online. This is what it looks like. It is hosted by Mass Legal Help, which is a great resource, whether you're looking at housing law or any other type of law. But they host this online, and all of the chapters are available. Again, it's going to answer a ton of different questions about a ton of different topics that you might have regarding this. So once I get into all the information, if you want to find more about that, or if you want to check the sources, if you want to see what the law is that it's referring to, this is a great resource to have, and it's completely available online. Or again, you can visit your local law library and view the print version if you prefer that as well. All right, so before we get into it, the main things that you need to remember, because you saw the law about pages and you saw Legal Tactics completely online, is that you can find that information again. But the main things that I really want to hammer in here is make sure you get it in writing. Again, whether you're a landlord or a tenant, make sure that whatever you have is in writing. Read it twice, make sure you understand whatever documents you're receiving, whether it is a lease or a complaint from a tenant. Keep good records of the apartment, whether you're moving in or you're the landlord. Take pictures, and those things are really going to help in any of these cases. So, and remember, whether you're a landlord or a tenant, you do have rights in these situations. So, are there any questions before we start off? All right, let's get into it then. So we'll start at the beginning of the landlord-tenant relationship, which is the lease, or generally the agreement to move into a dwelling. So generally we do recommend, before you rent a place, if possible, go look at it in person. I actually had a friend who signed a lease, showed up to check out the place, and he had been scammed out of all of his money, and it was not actually for rent. So we do recommend that you take a look and make sure that you understand what the apartment is and the condition that it's in before you do sign a lease, if you are a tenant. When signing a lease, there are specific things that a landlord can only charge, or specific things that only a landlord can charge. So it's going to be first and last month's rent, a new lock and key, the charge for a new lock and key, a security deposit that is no more than that first month's of rent, and they cannot charge, or landlords cannot charge pet fees, cleaning fees, or application fees. And starting in August, broker fees must be paid by the party who hired the broker. So broker fees can no longer be passed along to the tenant if the landlord has hired the broker to help find a tenant for that apartment. Lastly, read your lease carefully. So if you're a tenant, you want to make sure that all of the information that would make the lease valid is included, and we'll talk about that in a second. And you want to make sure that you understand all of the agreements between yourself or the tenant and the landlord in there. To make sure that your lease is legal, both you and your landlord need to have signed the lease. And then within 30 days, you must have a copy from your landlord. Often landlords provide the copy right away as soon as it's been signed. But in order for the lease to be valid, you have to have the amount of rent listed there, the date in which your tenancy ends. If you don't have an end date, then you are considered a tenant at will and not a lease tenant, but we'll talk about that in a second. The amount of your security deposit, if you pay one. And all of your rights concerning the security deposit, which we'll also talk about in a second. And then the names, addresses, and phone numbers of your landlord and the people who are in charge of maintaining the property. If this information is not in the lease, then it's not a valid lease. So there are such thing as illegal clauses. So just because something is in a lease doesn't necessarily mean that a landlord is allowed to put that in a lease. So here's some examples that Mass Legal Help has listed as illegal clauses in leases. So a clause that says the tenant is responsible for making all repairs. Just because that's in a lease does not necessarily mean that that is legal. A clause that says a landlord can use a tenant's security deposit to pay for utilities, or another reason that's outside of the law regarding security deposits and what they can be used for. A clause that says a tenant must pay for electricity or gas when it's in the landlord's name. And a clause that says that immediately upon early termination of a lease, a tenant must pay all rent that is due. So while a tenant might be liable for several months' rent at that point, the landlord does have a responsibility to find a new tenant at some point. So a tenant does not necessarily have to, if they break a 12-month lease at 6 months, they don't automatically owe 6 months' rent. So as I mentioned, if you don't have a lease, then you are considered a tenant at will. And this is also considered a month-to-month tenancy, and this can be a great option for a lot of people, especially if you just need something short-term, or if you're waiting for some sort of public housing or a senior assisted living option to come through. You don't necessarily want to be stuck with a 12-month lease if that option opens up for you. However, without a lease, a tenant at will doesn't always have the same protections that a lease tenant has, so you have to balance that out between the two. There's no guaranteed length of stay, so you might want to stay somewhere for 12 months, but a landlord can 100% serve you an eviction notice for no cause after 3 months, and then you have to find another place to stay. So these are important things to consider. If you are a tenant at will, your rental agreement is either oral or it's not written. Or you might have a written agreement with the landlord, but it doesn't include that rent amount or the end date that we just talked about that makes a lease valid. And finally, you might have had a lease before, but it expired and you never signed a new lease to renew. You and your landlord just decided, okay, well, you're a great tenant, we're just going to move forward with this as long as you keep paying rent. And just because you had a lease before, you don't still have those same protections. You are now a tenant at will. So any questions about leases? Yep.
So this assumes you're already found a tenant.
Yes.
Are you going to go over at some point the application of a tenancy? So when you take applications, what you can ask, what you can't ask.
I wasn't, but afterward we can definitely take a look. I'm pretty sure that there is information on legal tactics about finding a tenant. So yeah, we can definitely take a look at that in a second.
What about an automatic renewing lease?
So it depends, again, it depends on the language of the lease. But yeah, generally if it has, the lease has to have a end date. So unless you sign some sort of amendment that changes the end date, then you would become a tenant at will. So it depends on the language, and so I wouldn't be able to take a look at your lease and state, oh yeah, that's going to be legal or not. But you just have to take a look at how it is automatically renewing.
It's the lease that says it's automatically renewing.
Without looking at it, it sounds like that's probably not going to be automatically, like, it sounds like it would be a tenant at will situation after that original lease expires. Any other questions? Yeah?
If you had a broker, is a realtor a broker, considered a broker? If you go, hey, realtor, I'm looking for a tenant, they all have an open house.
Mm-hmm.
Is that the same as a broker? And the tenant used to pay for that service
Right.
because they were looking. Did that change?
Yes.
Okay.
So if a landlord goes to a broker and asks them to do an open house to find a tenant, and they are paying for that service, now the landlord is responsible for paying that fee.
Then how else, the only other option to find a tenant would be on your own?
Mm-hmm. Yes.
Thank you.
All right, utilities. So we get a lot of questions about utilities, specifically water utilities. So I just wanted to go quickly over who generally pays for utilities in Massachusetts. And the easy answer to this is unless there's a separate meter, the landlord is paying utilities. So often in Massachusetts, especially for older buildings, there is no specific submeter for every single dwelling in the apartment. So it's impossible to know which, if apartment 1 or apartment 20 is using how much water. So that's going to be the responsibility of the landlord, and often that'll be built into a lease. It'll say the landlord is going to pay for heat and hot water if it's all the same water source. And it's the same thing for gas, electricity. There has to be a submeter to that apartment. And that's easier to do for electricity. So you often see that's not really an issue. That's going to be under the name of the tenant, and the tenant will be responsible. But especially for water, that's often going to be the landlord's responsibility. Now, if you have issues paying for any of your utilities, there are some options. So often gas and electric companies offer discounts, especially if you have if you're low income or if you receive government assistance. There's also the fuel assistance program, and this link allows you to apply for that if you do need assistance. If you're behind on payments, you can always ask the utility company for a payment plan. But also note that if you owe money from a separate apartment and you move and you try to sign up with that same utility company, sometimes they will not turn on that utility until you settle your previous debt. So please keep that in mind if you are in arrears with any of the utility companies. Okay, any questions about utilities before we move on? Yeah.
So you said if the water has a separate, because I've had like separate different tenants, and the tenant that I have now, the water's not $300. I think it's outrageous. If I do put a separate meter, they could pay for their own water?
Yes, as long as a separate meter only goes to that dwelling, and they can run exactly how much they're using and only pay for that.
Okay.
So yes.
And I'm not required as a landlord to pay for their water if they have a
Nope, if you have a separate meter, then you can have the tenant pay that.
Great, thank you.
All right, another common question we get is when can a landlord enter your apartment, your dwelling, your home? And generally, yes, a landlord does need to have permission to enter the dwelling, though by law there are legitimate reasons that they can come in and that a tenant should allow their landlord to come in. So if you have a lease, a landlord can only enter your dwelling if they need to inspect the apartment or perform repairs, and that extends to their agent. So for example, if you call your landlord and say, hey, my toilet has exploded, you need to allow them to come in or the plumber to come in to fix that toilet. If you are they can also come in at the end of your lease to show the apartment to prospective tenants once you've had that conversation and you know that the tenant is not renewing. If you are a tenant at will, the landlord can enter to make those same repairs, but also if they have a court order to do so. And then other general reasons that are a little less likely, but if your apartment appears to have been abandoned, a landlord can enter the dwelling. or if they want to inspect the dwelling, again, in that last 30 days of tenancy, regarding security deposits and damages, or again, if they have a court order to do so. If the lease states any other reason why a landlord can enter the tenant's dwelling, it is an illegal clause. These are the only reasons why a landlord can enter. I am haunted by a chat that we had a couple years ago that was a couple young women who were living in an apartment, and there was a free room in there, and they had a clause in their lease that the landlord could just come in and use the room whenever he wanted. And so sometimes they would wake up on the weekends and he would have spent the Friday night in that room, and I told them, oh, absolutely not. That is definitely an illegal clause, and I think about them all the time, and I hope that they were able to assert their rights and not have that landlord just popping in whenever. But yeah, so those are the only reasons that a landlord can enter the dwelling. Yes?
It says if you have a lease, the landlord can come in and inspect the but if you're a tenant at will, I had a lease for a year, but then after that it was tenant at will.
Mm-hmm.
Now, they can come in to make repairs, that's only if you know about it, right? Or you
Yes, they
ask.
do have to notify you and generally get
Or if
permission.
you have a court order, but now, what if they're gonna sell a house? Can they just have people come in at any time?
Nope. So again, yeah, if at any time for any of these reasons, a landlord should contact you and provide notice and get your permission to do so. So that even if they say, like, I'm going to be there at 2 tomorrow, well, wait a second, like, maybe I'm not there, or maybe, like, I'm having a party or something, and you can negotiate when that would be happening. Now, obviously, if there is like a emergency utility, then maybe cancel the party and make sure that someone can get in there. But yes, a landlord should get permission before they enter the dwelling. Excuse me. Yep.
Do you know if this applies to, like, some kind of venue to make downtown have assigned parking spaces? If a landlord, he rented the parking space to tenant,
Okay.
could a landlord say, I need the parking space when I show up? Is that kind of the same thing?
They need a parking space for
They
what?
need to use the parking space when they come in, the tenant has to vacate the parking space.
I-
Do you know if this would be applicable?
I don't know if this specifically would be applicable, but if it's in the lease that is the tenant's parking space, then that's the tenant's parking space. So they wouldn't be able to they wouldn't necessarily be able to kick out the tenant just so they can use that parking. They should have their own parking if they're, yeah. Yeah.
I'm sorry, I just want to clarify.
Sure.
The difference between if you have a lease and you don't have a lease.
Mm-hmm.
So, I think that follows from what she was saying, they cannot enter just to inspect the apartment, do that by tenant? No.
Right. So, yeah, that's just based on the language of the law. So I don't know if they just didn't include that or, yeah, but for whatever reason, the lease lists those 3 reasons and the tenant at will lists only those 2 reasons.
And so if you know a tenant at will and you've already given them notice to leave, or they're giving you notice, within that last 30 days, you still can't just come in to show the apartment?
No, generally you would have to, yeah, again, you can ask permission, but if they don't give permission, then no, you don't have to let them in. All right. So speaking of, we talked about getting repairs a little bit, so let's talk about getting repairs made. So if you are a tenant, you have the right to a decent place to live. And again, these standards are listed in the State Sanitary Code, which is 105 CMR, the Code of Massachusetts Regulations. And so if you, as a landlord or a tenant, are concerned, okay, maybe the water isn't hot enough, maybe the facilities or something aren't up to par, you can locate all of that information here in the State Sanitary Code. And again, this is via that landlord tenant page, but I'm sure if you Google it as well, it'll pop right up. It's free. You can view that from any computer. And there are some options regarding getting repairs made. But first, you would be astonished how many people reach out to us and immediately say, my sink isn't working, can I sue my landlord? No. You have to reach out to your landlord and report the repair and ask that to be fixed first. There's a set of there's a process that we recommend in order to do that. You can't immediately just jump to it as soon as something might break in your apartment. So again, you have to report the repair or emergency to your landlord immediately, and you must give the landlord reasonable time to make repairs. So reasonable time is not defined by law, it's more about the situation. So again, if your toilet has exploded and gallons of water are floating into your apartment, that's going to be a much shorter reasonable amount of time than, say, a light is broken. or there's a small drip from your sink, right? So not saying that they should take, a landlord should take months and months to fix the latter examples, but a reasonable amount of time is kind of subjective based on the repair that is needed. If a landlord does not make necessary repairs, then we recommend that you send them a letter in writing describing the repair, and keep a copy of that so you have that for your records. Again, keep good records. If the landlord still does not respond, send another copy via certified mail. Again, so you can get that notice that they have received it, but they still aren't moving forward with the repair. And then if they still don't respond, you can contact your city or town board of health and ask for a complete inspection. And oftentimes, any other future steps are really based on whether or not the city board of health has found issues within that apartment. We do, just on a legal basis, recommend that paper trail either on both sides, so you can say, look, I was notified of this on this date, or I notified them of this on this date, and that way if it does proceed to a court process, you have receipts, right? So the tenant does have some options if a repair does not get made. One of them is a tenant can withhold rent. So they can withhold rent if they have appealed to the landlord in writing to make necessary repairs, or the Board of Health has inspected the apartment and found code violations, or if that tenant is current in rent, they aren't the cause of the problem. Sometimes these things just happen, and the unsanitary conditions don't require the apartment to be vacated. So again, not a foot of water in the apartment, but something smaller. But in that case, if they do withhold rent, once the landlord does make repairs, they do still owe that rent. They don't just get a couple months of free rent. Another option is that a tenant can deduct up to 4 months of future rent to pay for repairs themselves, but the possibilities for this are a little more stringent. So you have to make sure that the local Board of Health has certified that the present conditions endanger your health or safety. So that's where that inspection report comes in. The landlord has received written notice, and the landlord is given 5 days from the date of notice to begin repairs or to contract for outside services, or 14 days to substantially complete all necessary repairs. If that doesn't happen, then you can deduct up to 4 months' rent to pay for that. And because you're paying for those repairs, or the tenant is paying for those repairs themselves, they don't owe that rent to the landlord after it has been completed. So there are a couple other options. You can file a tenant petition in the housing court, and this is the beginning of the document. You can find this online or in Legal Tactics. And there is an entire chapter on taking your landlord to court, so which I'm sure would be helpful on both sides if you want to explore those legal tactics. So any questions about getting repairs made? Okay, so moving on to security deposits, another big topic that we get. And again, there's an entire law about page on security deposits. But generally, at the beginning, when a landlord receives a security deposit, by law, they must keep it in a separate Massachusetts bank account than their other accounts. They have to give the tenant a receipt of where their money is being held, because a security deposit is the tenant's money, it's not the landlord's money. And they do have to pay the tenant interest on their security deposit every year, which obviously, generally based on the bank is going to be $1 or $2. So it doesn't add up too quickly. But I'll mention this in a second, but not putting the security deposit in the proper accounts can result in the tenant getting treble damages or triple damages if they do not receive their security deposit back. So it's very important to do so. Yep.
So my understanding is the landlord has 30 days to put that
Mhm.
in the account, and if they don't, would you recommend the landlord giving back the security deposit, or?
So yeah, we'll talk about that in a second, but basically if you, a tenant has to, or a landlord has to provide that, as you said, within 30 days, or if they are using it, an itemized list that deducts, so basically explaining why you're not receiving, or why you're not returning the security deposit. Otherwise, the tenant, if they don't receive either the itemized list or the security deposit back, they can potentially get triple damages from the landlord.
Does that
Yeah.
include, if you say you never put the money in the security deposit? in the
Yes.
bank,
Yeah, and here actually,
If you didn't do that,
yeah,
are you automatically liable for triple damages?
yes. Yeah, and I'll show you that in just a second. So first, what can security deposits be used for? So they can be used before you move out, or before a tenant moves out, and after a tenant moves out. So if if the tenant and the landlord agree to fix some sort of damage in the apartment during the tenancy, they can use the security deposit. But again, the tenant and the landlord have to agree to use that. And say again, you had a crazy party and somehow there's a hole in the wall at the end of the party, right? You can agree with the landlord, okay, let's use part of my security deposit in order to fix this. And then you would receive afterward that deducted list saying, hey, remember we used part of your security deposit to fix that, and here's the balance potentially if they don't need anything else. Now, after a tenant moves out, a security deposit can be used again. Maybe you didn't report that hole in the wall and now you've moved out and there it is. So they can, a landlord can use the security deposit to fix that repair. But again, it can't be used for reasonable wear and tear. So like the cost of repainting the apartment, for example, or maybe there's like small chips on certain things. But reasonable wear and tear, again, is not legally defined. So it really depends on kind of the context of the situation. A security deposit can also be used for unpaid rent unless it was legally withheld, like we just talked about. And then on the more rare occasion, if the contract requires it, unpaid real estate tax, which honestly I've never personally seen, but if that's in your contract, a security deposit can be used for that. And then to address your question, so a landlord has 30 days to return the security deposit to the tenant, as I mentioned, or provide the tenant with a detailed list of damages that either explains why they took the entire security deposit or part of the security deposit and return the balance. And a tenant may ask for 3 times the amount of the security deposit if the security deposit was not in the separate account that it should be. If there was a transfer of property ownership during the tenancy and the new owner did not receive that new account with that security deposit, or if the landlord failed to return the total balance within 30 days. Yes?
Wouldn't you have more than one apartment? You need a separate account for each apartment?
Yes. Yeah, because again, it's the tenant's money, and so you wouldn't necessarily be able, like, it would be 2 separate people. It would be strange for me and my neighbor to have the same bank account. So we would have separate accounts.
Okay, thank
Yeah.
you.
I've been told by the bank they're not interested in, like a $500 or a,
Mm-hmm.
so where do you go to find a bank that will take it?
Yeah, I mean, it depends on the bank. So you might have to go to a separate bank to do that. I don't have a specific list of banks, but yeah, there are certainly banks that will open up a security deposit. Yeah. So any other questions? Yep.
So what was the question?
If there were banks that would allow like a smaller deposit depending on how big the security deposit was. But unfortunately, I don't have a list of banks that would allow like a $500 deposit or something like that. So it depends on the bank. Yep.
I'm just realizing what this says. So from day one of you renting,
Mm-hmm.
and if they collect the security deposit, that should have been in a separate account, and I should, that the tenant should know where it is.
Yep.
and-
Yeah, you should have a receipt. So, but again, it also takes about 30 days to sometimes to get a copy of the lease, but oftentimes that information is, provided to the tenant all at once. All right. So, and then the end of the tenant agreement, or the negative end, hopefully none of us have to experience this on either side, but I just wanted to talk about eviction for a second. Oh, yeah.
Can we go back to the other thing for
Sure.
a quick second? Does it have to be in a Massachusetts bank?
Yes, and I can double check that, but yes, it has to be at a Massachusetts bank.
And there's a minimum interest rate too.
Mm-hmm. Mm-hmm. Okay, so eviction. The general eviction process starts with the serving of a notice to quit. Now, this is not an eviction notice. The notice is just a landlord telling a tenant that is their intention, that they should remove themselves from the dwelling. The two most popular, or I guess most common notices to quit are the 14-day notice for when a tenant owes rent, and a 30-day notice, which could be for no reason. Maybe there was a change of ownership, some fault, or some other violation within the lease. And then the 7-day notice is a more recent addition to these notices to quit. Excuse me. Which is because of a violation of some leases, and there's more information about 7-day notices on masslandlords.org. Excuse me. And then there's the no notice. So if a landlord accuses a tenant of illegal activity, then they are able to serve them with a notice to quit immediately. There is no 14-day or 30-day period. Oftentimes for the 14-day notice to quit, if the tenant pays their rent, then they'll just waive, the landlord might choose to waive that, and they won't, they will consider that the tenancy is back on track and good to go. But the 30-day notice obviously doesn't really have a remedy for that. So if the tenant obeys the notice to quit, then that's it. They remove themselves, and then the landlord is free to potentially rent this apartment again. However, a tenant does not have to move out by the date listed on a notice to quit for any of these 7-day, 14-day, 30-day. They do have the right to stay there, and that's when a landlord would start the eviction process in court. And the tenant can stay in the apartment during that entire eviction process. The landlord would then file in housing court. There would be multiple hearings, and then a judge would decide in favor of one or the other. If the judge does issue an eviction order, then the landlord, with the assistance of a sheriff or constable, can go to the dwelling and proceed to evict that tenant, but only with the eviction order signed by the judge. Yes?
Well, that whole process is taking place. The tenant, assuming is not paying any rent, so the
Correct.
landlord has to absorb the person who's rent-free.
Yes.
While this process plays out. which
Yes.
is paid.
How long does it usually take?
It depends on the housing court. So as you can imagine, like the Boston housing courts might be more busy than a housing court out west potentially. So it depends on the individual housing court and how quickly they're processing cases.
Have you seen,
Yeah.
cases or any cases, I guess, that are trying to ease up and make it friendlier toward the landlord and less tenant friendly? Are there any cases like case law come through on that?
No, this is pretty much the standard way. Yeah, and it's definitely the consensus is definitely that it's not landlord friendly. Yes.
So with the 14-day or the 30-day notice to quit, the tenant pretty much follows the notice to quit by that time. Will they still be able to go to court? Like the landlord will still be able to go to court?
No, because if you receive a notice to quit for 14 days and you're out by 14 days and the apartment is empty, it's all in good shape and everything, there's no reason to continue that process in court because you don't have to be evicted. You know what I mean? Like you've already left of your own accord. So there's no court process, if that makes sense.
Like what if the tenant still wants to be here?
Well, then yes, if you refuse to leave, then yes, the landlord can proceed to start the eviction process. And then the tenant would have the ability to kind of voice their side during the hearing trial.
Even if they owe rent or whatever.
Right.
They still have to go to that.
Yes. Mm-hmm. Any other questions? So there's a lot that goes on with evictions. So if you do have any other questions, mass.gov has a guide specifically for tenants and specifically for landlords. So you don't have to decipher like legal tactics in order to do this. They have guides for both sides. Again, there's links for the housing court forms for both sides, but strangely, there is no form for notices to quit. So if you need samples of that, you could always contact us at the trial court law libraries, and we're happy to send that out, whether it's a lease tenant, a tenant at will, a 14-day notice, a 30-day notice, etc. We have samples of those in our legal databases. And we send those out every day. So please contact us if you need sample notices to quit. And then finally, if you need eviction help resources, evictionlegalhelp.org is a great place to start to find more resources on that way. And I believe if you are a tenant that is being evicted, Eviction for Tenants also has resources listed. Another new law. So it's been a big year for landlord-tenant law in Massachusetts. But there is a new law regarding sealing eviction records, and this went into effect in May. That basically states that a tenant can petition the housing court to seal eviction records, but sealing is not automatic. So just because you have been evicted before, that is not automatically wiped with this law. You do have to petition the housing court to seal that record. And part of this law also states that it is illegal for consumer reporting agencies to include information about sealed eviction records. So if a tenant is successful in sealing an eviction record, it's not going to show up on their background checks if a landlord is running that. Now, again, this is not automatic, so and there are stipulations for when a tenant can petition to seal. So these first three options here, so if a tenant does win their case and win an eviction case, if a case is dismissed, or if it's a no-fault eviction case, again, maybe it's a transfer of new ownership, and the tenant didn't do anything wrong, but the new owner wants all new tenants. So in that case, after the tenant can immediately petition the court to seal an eviction record. In those other cases, if there's a non-payment case, the tenant, if there's a non-payment case where the tenant has satisfied the judgment by paying the amount owed, so they did owe rent, they paid it, the debt is clear, then they can apply as soon as they've satisfied that judgment to seal their record. In a non-payment case where they have not, it takes 4 years for them to do so, and the debt is not forgiven. Even if the record is sealed, the tenant still owes the rent that is that they owe. And then in a fault eviction case, they have to wait 7 years after that case to file to seal their record, and they can't have any other fault evictions in that 7-year period. So that just continues to extend that period if they do want to seal their record. All right, and then finally, we talked a lot about non-payment of rent and utilities and all of that. So there are some options in Massachusetts regarding payment assistance, and this includes tenants, landlords, and homeowners. So if any of you need help with on the short term with paying mortgage, rent, or utilities, you may be eligible by applying for RAFT, or the Residential Assistance for Families in Transition, and you can do so here at applyhousinghelp.mass.gov. And this also includes other services like emergency housing assistance, finding affordable homes or apartments. If you are a tenant that has been evicted and you're looking for a place to stay, they can potentially help you if you're eligible. So definitely visit this if you are in need. And remember to complete your application so they can process that need right away. Yeah?
Can a landlord apply for assistance on the tenant's behalf?
I'm sorry, on the whose behalf?
On the tenant's behalf?
I don't believe so. I believe it has to be the tenant. Yeah?
So, I just learned about the seal records.
Mm-hmm.
Are you allowed to ask potential tenant that whether an active eviction is in process, or were there any records that were sealed while you were screening?
I think similar to a criminal record being sealed, once it's sealed, I don't believe that you can ask that. No.
You can ask.
Right, because it's been sealed. All right. And so I know that was a lot of information that we just went over. So again, remember to get it in writing, read whatever you have in writing twice and make sure you understand. Keep good records, take photographs, and know that you have rights in landlord-tenant law. So again, I'm happy to share this presentation with anybody. So these are just quick links if you want to specifically go somewhere real quick, and more resources online. And with that, that is my presentation, and I'll get to your questions, but thank you so much. All right, so I think I saw you first, yes.
So we were talking about security deposits, because the gentleman here in the green said there's a minimum interest rate that's required.
Mm-hmm.
The state has?
Yes, so I can look this up here, but I believe it specifies
and
in the law.
So if the bank doesn't pay that interest,
Mm-hmm.
you have to supplement it? person agreeing here?
I think it's prevailing rate.
Sorry, yes.
I think it's prevailing
Yeah.
rate. It used to be 5%.
It used to be 5%.
Yeah.
Yeah.
I mean, go show a bank that pays 5% today on a cash loan.
Yeah, I'm not sure that the
So
laws,
it's
I mean,
prevailing rate.
yeah.
What-
So what is the prevailing rate?
Yeah.
1% for.
But yeah.
So usually banks would know the drill, right?
Yeah.
If you go
Yes.
to one local,
Okay.
they have C deposit,
So
so
that-
that pays it annually for you.
Yeah, okay, yeah, all right.
Yeah, and real quick, while I'm again very happy to answer any questions you have. I'm just going to put these over on the table, so if anybody does want to look through them, you can feel free to do so. Just, I don't think anyone has a library card here, so please don't take it. We do want this, but if you do want to check it out, visit us here, and you can apply for a library card and check this out and keep it for 2 weeks.
How do we get on the list to get this presentation sent to us?
Yes, that's.
So you can either email me, or if you want to email the Memorial Library, they also have a copy. So
Oh, okay.
whichever one.
What's your email?
So Norfolk Law Library.
Oh, the library there, yeah.
Yeah. And then we have very long at JUD.state, government emails. Go ahead.
The gentleman back there asked about what questions you can and cannot ask a prospective tenant. Can you talk about that?
I can see if there's a specific list of those, but generally it's going to be, you have to respect certain like discrimination laws. You can't specifically ask about like certain statuses. But yeah, I can definitely check to see if the Landlord Survival Guide has a list of kind of prohibited questions here.
Yeah.
So yeah, and then if we don't find that, I can take down your information, and I can always look for that tomorrow too. So if anybody has any questions that they don't want to ask in front of everyone, feel free to come up. I'll grab your information and I'll look at that first thing tomorrow morning.
What about in the screening process? I heard someone tell me that you can't ask for credit reports or your FICO scoring, or you can't
Yeah.
put credit.
As far as I know, I'm not familiar with that being a banned.
Did anybody hear that?
No, you can do that.
Yeah.
You can ask for credits.
You could even specify a credit rating. Don't.
Yeah. I know when I was still renting, I'm pretty sure I had to provide that. So as far as I know, that's not prohibited. Yeah.
One of the slides also says that you can't charge application fee.
Yes.
But if you're going through Zillow or some of the common platforms, you want to avoid potential hell, the Zillow would charge it.
Right. So that might be the responsibility of the landlord if Zillow is charging for the use of their platform.
Correct. So let's say, I don't know, 50 people apply, hopefully one buys, one signs in. So you're responsible for 50 applications or one which went through.
So if the landlord would be responsible for paying the fees that the platform is.
Yes.
Yes.
I know, but 50 potential tenants apply.
Yeah.
Each one costs $40.
Mhm.
But I think only one tenant will successfully get into lease,
Mhm.
right? So I understand landlord covering for one lease which he or she signs with a potential tenant. But what about the other 39? Is the landlord supposed to?
A landlord. All I can say is a landlord cannot charge application fees based on the law.
Landlord isn't charging, but Zillow is charging for his property, right?
Yeah.
It was the landlord or charging?
Right. It,
No, just the Zillow and just the online platform. So the landlord is not charging anything.
it's possible that the tenant might be responsible for that if they are, but if the landlord hired Zillow to do that, that gets a little murky.
It is murky, that's all.
Yeah. So yeah, I guess I would probably need more information about like how Zillow is doing that. But yeah, generally during the lease signing process, the landlord cannot charge application fees in that process.
During the lease signing process.
I can double check, but that's normally how.
Because that would help a lot of things.
Sure. Yeah. And again, will most likely be in those two things, so we can look at that in a second.
One last question.
Yeah.
before I stop talking to you.
Not a bother. That's what I'm here for.
So you mentioned about records and very quote-unquote paper trail, but nowadays we use SMS and
Sure,
email.
yeah.
So what does the Massachusetts law dictate? What is considered as record?
The texts definitely count. We have people on either sides for any type of law coming in and printing out screenshots, anything like that. So yes, a text is considered something in writing, and that can be submitted as discovery in court cases.
For both sides.
Mm-hmm. Did I see another question in the back over there, or? Okay. Yep.
So if there's no pet fees allowed, what about pet rent?
I don't believe that pet rent is allowed either. So that would be something that, like, if you are opening as a landlord, if you're opening your apartment up to individuals with dogs, you might consider having like a higher rent to cover for that if you do want to have, you know, a little bit more wiggle room for pet-related damages.
So that's blended in the rent?
Yes. Yep.
I think that Avalon complex in Norwich charges pet fees.
Well, they shouldn't be doing that. So, yes.
I think I've seen it on their stuff.
Mm-hmm. So yeah, that might be something that any tenants there, they would be able to take a look at the law and know that they cannot charge pet fees. Yep.
And it's not illegal if you say, no, we don't want any animals in the
Yep.
apartment.
I mean, that would be part of the advertisement for the apartment saying, nope, yeah, having pets is not a discrimination or not listed among those that you cannot discriminate against in Massachusetts. However, you can't discriminate against breeds of dogs in Massachusetts. That's important. So you can't say all dogs except for, you know, Rottweilers and Pit Bulls. Though I believe that you can say no dogs over 40 pounds, for example, but you can't have breed-specific violations or things like that.
Could someone show up and have an emotional support cap that?
They could,
And
but.
would the landlord be required then to take that cat when he had said no pet?
So we get a lot of questions about emotional support animals versus service animals. There is no legal right for emotional support animals. And this can be upsetting for those with emotional support animals, but they do not have the right to bring them into grocery stores or other public places. If they ban pets, only service animals can be brought into those places. So, and it doesn't matter, like, I have a friend who was conned, again, into, I get a lot of questions regarding these as part of my job. Yes. Who purchased a emotional support license for her dog, and I had to tell her that does not give you the ability to take that dog anywhere you want. Or if you just, you know, purchase a service dog leash on Amazon, that does not make your dog a service dog. But that's a whole other topic that, yeah, if you have more questions about that, feel free to contact us. Yeah, did you have something in the back?
When it comes to your service animal, is there been like a definition of what that encompasses? Like this criteria meets that? Because everybody, well, it's very frequent that you see people with service,
Right.
quote unquote, a service dog
Yes.
or a service animal.
So generally, there's no specific legal definition. However, there are two questions that you can ask somebody who has a potential service animal, which is, one, is that a service animal? And two, what is it trained to provide to you? It has to be trained to provide a specific service. So, you know, someone who might be diabetic might have a service animal to alert them if they're about to have an episode. Emotional support is not one of the not a service. They have to specifically, like, gather your pills for you, alert you to specific episodes, you know, that kind of thing. That's what a service animal would be. Emotional support is not one of those services. But yeah, we get a lot of questions about these. But yeah, any other questions? Or again, please feel free to take a look at those materials. Legal Tactics is available completely online. Yeah.
Are there resources that you listed about, like, going back to security deposit for more
Mhm.
wear and tear? Have you found any resources that attempt are better than others that are attempting to define examples?
It really is a case-by-case basis. So there is no legal definition. Because it's a case-by-case basis. It's just like a reasonable amount of time for a repair. So because there's so many variables within that, there is no legal definition or no case that specifically states one way or the other what a reasonable wear and tear is. Yeah. Yes.
I was going to ask, if you are looking for your own tenant,
Mm-hmm.
you mentioned that you can ask if they have ever been evicted before, is that how you put it, or have they any problems that they want hidden? I don't know
So
They said it.
once they have a sealed record, they don't have to tell you if you are evicted. You might ask, like, have you been evicted before? But if a tenant has successfully petitioned the housing court to seal that record, they don't have to tell you, yes, and also I sealed that record. They can say no because it's been sealed.
But I'm really asking, when you just say you're filling out an application
Mhm.
to have my apartment, is there a way I could find out without asking them specifically, if I have their social security number and their name because they're applying for my apartment?
Yeah.
Can I look up anywhere that they have been evicted in the past?
Yes, unless they have it sealed. Yes.
How do I look that up?
You can run a background check,
Housing
or
court.
yeah.
I'm sorry, say it again?
Housing court.
Yeah, you can look at housing court. So it's actually about to be down for 3 days, but masscourts.org is the public records website for Massachusetts. And so if you do have to go to the specific county in court, but you can then search by name. So you can't just go to mass courts and put in someone's name and see every single thing if they have, issues in multiple counties, but you can go to Norfolk County Housing Court and then search and see if they've had any other housing court violations or issues. Yep.
So background checks cover the basic background checks.
Mhm.
There's additional ways you can do, like any evictions, any other illegal activities. My experience has been that it's probably 1 or 2 clicks down the reports that you get. And yet there's a whole other series. If you know somebody,
Mhm.
they can run some information and you can get the truth. How do we, normal people, get to that if you know somebody's set of resources?
Generally you pay for it.
Okay.
Yeah.
Well, it's okay to pay for that, but like, what are they? What are those
So
resources?
yeah, so unfortunately, like those types of commercial resources, I can't recommend.
Okay.
As yeah,
I understand.
yeah, if that makes so.
Now I
Yes.
get it.
But again, on masslandlords. I think it's either .org or .net. They'll probably have some resources available. That survival guide might have some resources that they outline, but we just can't specifically, as government employees, advocate for one commercial service or another. Yeah.
Quick question. So, if you gave your tenants another lease
Mhm.
and they disagree on like the terms because the rent is going up, legally, how long can they stay with that price until you raise the rent to that other amount?
Until the end of their first lease.
So so it's not like a 3-month grace period until, so.
Nope. So yeah, the original lease might say, you're going to pay $1,500,
Yeah.
and then the second lease would say you're paying $2,000. So once that first lease is terminated,
Yeah,
the new price would go into effect.
okay, even though they didn't sign it.
Well, no, if they haven't signed it, then they haven't agreed to that, and then if they refuse to leave after the termination of their first lease, then you may want to consider eviction.
Okay. It's not like a 3-month grace period?
No.
No? So
Nope.
we can terminate them and
Yeah.
evict them, go into that?
Yeah, if they didn't want to sign the new lease and that's the terms in which the landlord is providing to them, and they didn't agree to it, then they're not paying that rent, then yeah.
They're paying the original rent, not.
Well, if a landlord then accepts the original rent, then they are now a tenant at will.
Okay.
So yeah, so that would be different than like non-payment necessarily, because they are still paying the rent. So that would then transfer probably to a 30-day eviction notice, or I'm sorry, a 30-day notice to quit.
Find a lawyer. It's called summary process. They want the money up front. They won't.
Yeah.
Good luck finding a lawyer.
Yeah.
They're good, they're still paying something at least.
Yeah. Yep.
If you increase the rent, you have to give them like a month's notice that it's going to be.
At the yes, yeah. So obviously, like again, if you're, if the lease ends August 30th, as a landlord, and for a tenant, it behooves you to review that with your tenant before that ends, because you don't want to be in that situation where you're kind of in that limbo between leases. So yes, definitely at least 30 days before, it's helpful to speak with the tenant regarding any changes in the lease and renewing that lease if you so choose.
The same with if you're a tenant at will?
Nope, a tenant at will doesn't have a lease.
Right,
So,
doesn't have a lease,
so that's one of the
they
lax of
have to
protections.
give you so much notice then to increase.
Yep, yeah, so generally like 30 days notice to increase rent.
I'm gonna increase it to another
Yeah, they couldn't do it tomorrow, but yes, they would have to give you notice, but they can change the rent amount for a tenant at will whenever they want, because there's no specific agreement stating that you will only pay this for this amount of time. Yes?
You get that 30-day notice prior to the lease ending, you get that in writing, I review with the tenant 30 days prior to the end of the lease, we're gonna increase the rent. You get that in writing that you met, talked about it?
Mm-hmm.
Let the tenant, you get that in writing, they sign also?
Well, that would be in the new lease. Sorry.
About rent increase, right?
Yep. Yeah, so that would be something that you would provide the new lease that would have the new amount in there, and then the tenant would sign it to agree to that new amount.
And I was talking about the notice that the rent will be increasing.
Yeah?
Should that be in writing? And signed?
Yes. Yep.
I'm sorry, I spoke exactly what they're asking. So you have, say it this way. So you have a tenant at will.
Mm-hmm.
You give them the 30 days notice that the rent is increasing.
Mm-hmm.
They have to sign something that says they agree to that? Or-
Generally, that's good practice, yes.
Okay, because otherwise, if they don't, they could just keep paying what they paid, or?
So a landlord can accept the old amount, but they're accepting rent, so they're continuing the tenancy. If they want to increase the rent for that tenant at will, and the tenant does not agree to it, then they can start the eviction process if the tenant does not pay that extra amount. All right. Any other? Yeah.
Last one. This is probably a crazy question, but do Airbnb people that are like 3 months or 6 months in a house, do they have any rights in Massachusetts under?
I'd have to take a look, but there is a law about page on squatters' rights. So it depending on how long they're there, it might be considered in that topic. So I recommend taking a look at the law about squatters' rights. But oftentimes as well, on Airbnb you have it's not a traditional lease, obviously, but there is a contract that would state that they are leaving at a certain amount of time. But there have been instances where, so-called squatters' rights are applicable in that situation. Sorry?
Unless they want to keep their 5-star.
Exactly. I think, it would definitely tank otherwise. Any other questions? All right, well, again, if you have something that's more private, feel free to come up. But thank you so much for coming. You've been wonderful and great questions, so thank you.